Professor Blackman and Professor Devins with us. We're going to be doing this webinar. If you haven't been to any of our previous events, there's a Q&A function at the bottom of your screen where you can type your questions in. And Alex and I will be posing the questions after we finish the first part of the discussion. And so those will be shared anonymously, so don't worry about if your name is being shared. And you guys can type those in throughout the presentation, and we'll just start that after the main portion. But I'll turn it over to Alex to introduce our speakers.
Yeah, hi everyone. Hope everyone's having a good week. We're really excited about today's discussion, especially in the wake of yesterday's Senate confirmation vote and next week's election, just a week from today, I guess. We really couldn't be having this conversation at a better time. So today we're going to be hearing from Professor Devins and Professor Blackman. Professor Devins, as we all know, currently serves as the Sandra Day O'Connor Professor of Law and Government at William & Mary Law School. Professor Devins is a prolific author of law review articles and books, including most recently, The Company They Keep, How Partisan Divisions Came to the Supreme Court. And joining us today from Texas, presumably, is Professor Blackman. Professor Blackman is a professor at South Texas College of Law, where he specializes in constitutional law and the United States Supreme Court. He has authored over 6 law review articles and 3 books, including An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. His commentary frequently appears in sources such as the Wall Street Journal, USA Today, and other national publications. So with that, I'll turn it over to our panelists and we'll get started here.
Thank you so much, William & Mary. I really, of course, my phone rings the second I get called upon. I apologize. I really wish that I could be here with all of you in person, but this is the best we can do under the circumstances. We picked a pretty, boring time to talk about the Supreme Court. Nothing's going on. It's rare that we have so much action on the Supreme Court in such a short period of time. In the span of 4 years, we have 3 new justices. I think the last time we've had that rapid pace was in the Nixon administration. We were talking back almost 50 years ago. President Clinton appointed Justice Breyer, I think in 1994. And there was not a single appointment after Breyer until Chief Justice Rehnquist passed away in 2005. So we had almost an 11-year stretch without a single vacancy. And now we've had 3 vacancies in less than 3 years. So we're in a very tumultuous stage, right? And I think the Roberts Court, to the extent that it's settled into a bit of a pattern this past term, is now thrown in a very different direction with the admission of Justice Barrett to the court. But our topic today was a little more specific. We're not just going to talk about Justice Barrett. I want to talk about stare decisis on the Roberts Court. And I think that's a very significant topic in light of the fact that this may not even be the Roberts Court anymore. I don't know which court it is. So let's start with some basic principles. There might be some 1Ls in the call, so I'll give the terminology. Stare decisis is this old Latin phrase that means you stand by the decisions or you stand by the precedents of the court. And as you learn in every 1L class, stare decisis has value because people rely on the law. They understand what the law is, they understand what the precedents are, and they can form their expectations around it. So for example, if a court adopts a rule of strict liability for negligence, and they don't, they know there's certain strict liability offenses. If I'm a business, I know not to engage in strict liability offenses. I can structure my life around very simple legal principles, and that way I can, have some stability in my business. Okay. Stare decisis in the common law context is not terribly controversial. Because the common law is understood to evolve over time, right? You have these common law courts with the first restatement, the second restatement, right? And things sort of just move over time. But when you're talking about the US Constitution, the analysis seems to change a bit. There are some people who think that the Supreme Court is just a common law court and that it evolves precedents over time to fit the day. And other people take a more of an originalist perspective, that the court should follow the original meaning of the Constitution, which doesn't change unless there's an amendment to the Constitution. Lurking in the background of both of these poles, this originalism and maybe what you call common law constitutionalism, is this concept of stare decisis, right? The idea is even if the Supreme Court rendered a decision that might have been wrong on its own terms, should that decision remain in effect for other reasons? In other words, do you keep following a case even if it's admittedly wrong, because following a wrong decision might serve some higher purpose? Okay. The Supreme Court's most thorough statement on stare decisis has come in the context of abortion. I'm sure you know there was a decision in 1973 called Roe v. Wade. And Roe erected this very elaborate framework to review abortion laws, where if you're in the first trimester, basically abortions are not permitted, bans in abortion are not permitted. In the second trimester, there's some additional restrictions that can be imposed. And the third trimester, the state has more latitude to restrict abortion. And you know all this. After Roe, there was a very sustained effort to try to overrule the case. The Republican Party latched onto this case and sort of still latched onto this case. President Reagan and others worked very hard to put justices in the court who might one day overrule Roe. I heard Devins's chair, Professor Devins's chair is named after Justice O'Connor. That namesake suggests that this plan didn't quite work out. And we get to the year 1991 and the famous case of Planned Parenthood v. Casey. And this case suggested, could Roe be overruled in its entirety? At the original conference, according to some reports, there were 5 votes to overrule Roe. At that time, believe it or not, there were 8 justices appointed by Republicans. There was only 1 Democratic justice, Byron White, who was in dissent in Roe. So it looked like there were 5 solid votes to overrule Roe. And then magic happened. The votes changed. Justices Kennedy, O'Connor, and Souter came together and they wrote what's called a joint opinion, sort of plurality opinion, which kind of upheld Roe, sort of, not really. Like, it upheld parts of it, but not other parts. But that's not why I'm here today to talk about abortion. What I'm here to talk about is stare decisis. Casey gave, I think, the most thoroughly developed discussion of stare decisis the Supreme Court had ever done. Maybe I'm wrong. Maybe there's another one. That, in my mind, that's probably the most thoroughly developed opinion. And the court, or the plurality, seems to suggest that even if Roe was wrong, right, they didn't agree with Roe as a matter of first principles, they would stand by Roe because of what you might call reliance interests. What does that mean? Again, there's like the common law court. People, women in particular, had built their lives relying on the Roe decision, right? They understood that if the situation arose, they would be able to obtain an abortion under the circumstances that Roe said you could. And the court, I keep saying the court, but it was the plurality said, we have to respect that, and the court can't unsettle expectations. The court also said it would actually reflect poorly on the court if they changed their views whenever the composition of the court changes. And that's, I think, a very important point, right? A 5-4 decision today could be a 5-4 decision tomorrow if one justice is replaced, if the swing vote's replaced. And what O'Connor, Souter, and Kennedy suggested is it would make the court look really bad if Roe's overruled just because they're more conservative judges. That you need to convey to the public a stability, right? Even if the O'Connor, Souter, and Kennedy didn't agree with Roe as a first principle matter, they would stand by it. All right. So this was a very full-throated defense of stare decisis, and Roe was largely, not entirely, but largely upheld. All right, now fast forward about a decade, and then we get to cases involving gay rights. The Supreme Court in the 1980s had upheld a ban on homosexual sodomy. The case was called Bowers against Hardwick. 5-4 decision, the court said that there's no right to sexual relations under the 14th Amendment, and there are long-standing bans on prosecuting homosexual sodomy, as it was called in the day. Then we get to Lawrence in 2003, Lawrence v. Texas. The court overrules Bowers, and the court says Bowers was wrong the day it was decided, and it's hereby overruled. This disparity, right, In Casey, you upheld Roe, but in Lawrence, you ruled Bowers, created some tensions. And Justice Scalia dissented in both cases quite vigorously. No, I'm understanding. He was pissed off. He was livid. He's like, look, how is it that we're standing by Roe, but we're overruling Bowers, right? And I think Justice Kennedy, who was the majority in Lawrence, said, well, look, people aren't relying on Bowers the same way they relied on Roe, because people generally engage in their private lives and they're not worried about, criminal prosecution. Maybe right, maybe wrong. But I think what you're seeing with these two line of cases is stare decisis is not an absolute command. It's not what's called an inexorable command. There's some give, there's some play in the joints. And neither conservatives nor liberals have monopoly on stare decisis. It seems in some cases they're willing to rule it, or maybe they're not. One of the most significant cases is Obergefell v. Hodges, a gay marriage decision. There was actually a decision from the 70s, never heard of it, called Baker v. Nelson, which said that there's no question the federal constitution doesn't protect gay marriage. It's not even a close call. And the Supreme Court overruled that one. And they declared unconstitutional laws in many states involving marriage. Why do I give you this sort of wind up and background? Because the stare decisis debate is very controversial, right? Because generally, when you're in the minority, right, when you're in the dissent, you realize you don't have the votes to win the case. But you say, well, even if we're wrong, stare decisis. Okay. If you're in the majority, you have the votes to win the case. As a judge, you're still tugged by these strings of stare decisis. So it has this sort of gravitational force where it tugs you either towards a majority, towards a dissent. All right, so let's fast forward a bit to the Roberts Court. I'm going to use one example of precedent that I think illustrates this dynamic well. There was a case in the late 70s called Abood, A-B-O-O-D, Abood. The case concerned union dues. So if you're a public employee, what kind of dues can be collected from your paycheck for a public sector union? Unsurprisingly, a lot of government employees don't like having their salary cut. They want their full paycheck. So they objected to certain amounts of money being taken from their salary. In the 70s, the court said, no, you can do this, right? That the money is being used for certain negotiation and collective bargaining, and it serves a public good. Throughout the 80s and 90s, there were serious efforts to weaken public sector unions. People were not happy. They raised First Amendment challenges about compelled speech, but this dues case is always lingering in the background. In the mid 2012, 2013, 2014, there were several cases in the Roberts Court which suggested that Abood would be overruled, but they stopped short. Finally, in 2015, the court granted a case called Friedrichs versus California Teachers Association. You had a public school teacher that didn't want to pay the dues. And it looked like finally at last there were 5 votes to overrule Abood. But then Justice Scalia passed away. And the 5th vote vanished. And the court actually affirmed by a 4-4 majority. I'm sorry, by a 4-4 margin. When the court ties, there's no majority opinion. They just affirm and they move on with their lives. At the time, it looked like, well, I guess whoever President Clinton picks will save Abood. And I think Justice Ginsburg made a comment to the effect saying Abood is safe because Clinton will win. Yeah, didn't happen. Did not happen. Justice Gorsuch was picked. And about 2 years later, the court decides a case called Janus, Janus, where the court overrules Abood, completely overrules the case. That shows that the 5th vote is enough. In dissent, I think it was Justice Kagan, what was livid. She's like, how can you do this? This is a 30-year-old precedent. There were countless public contracts that were based. In other words, unions negotiated bargain agreements in reliance on this precedent, knowing that these dues were available, and now the dues were gone. Basically, all of these contracts were now unenforceable to collect dues. Justice Alito wrote the majority, and he had one line, a little bit smartass. He says, well, we've signaled in the past this case was in the chopping block, right? We had all these other cases saying Abood was bad. If you guys made a contract in reliance on the shaky Supreme Court precedent, that's on you, not us. I never found that argument very good, but in Alito's mind, there can't be reliance interest if you've given all these signals as cases in the chopping block. Okay. But let's just play out a counterfactual for a minute, right? What happens if President Clinton was inaugurated? And what happens if, in fact, let's say President Clinton put Merrick Garland in the Supreme Court, or maybe put someone to Merrick Garland's left? Pick your poison, whoever you want it to be, right? In the brief period after Scalia's death and the election, there was a very strong movement, maybe an effervescence, an enthusiasm on the left, saying, oh my God, for the first time in our lifetimes, we'll have 5 Democratic appointed justices. It hasn't happened since Abe Fortas stepped down in the 70s, or the 60s, I'm sorry. What are we going to do? And there were law professors, and Neil knows who they are, who were suggesting, well, do we overrule precedents? For example, Citizens United, a case that declared unconstitutional various restrictions on spending, on campaign spending by corporations near an election. Would you overrule Citizens United? What about guns? DC v. Heller was a 2008 case that said the Second Amendment was an individual right. Would you overrule Heller? A far more significant case is Shelby County. Shelby County v. Holder was a decision that declared parts of the Voting Rights Act unconstitutional. I can see a way to overrule Shelby County. It'd be a little tricky to get the case teed up, but it's possible. And at that point, progressives were saying, wow, we have a majority. What are we going to do with it? It's like when you're about to turn 17 and you're about to get to the keys to your first car, it's going to be either, it's like, okay, where's my first joyride? Where am I going to go? Right? What's my first trip going to be? And that's like, this giddiness. And I was like, oh, wow, this is real. And there were some progressives who said, wait a minute, we shouldn't be so, maybe we should stand by. Let's be calm, not overrule everything. Maybe don't overrule Heller. Maybe just limit Heller to the home, don't overrule Citizens United, just limit it, just sort of a moderation. But there were these debates that were ongoing. And then we had November 2016, and, well, depending on who you ask, President Trump won the election. Some people still haven't quite acknowledged that, but he won. He did. He was inaugurated. And President Trump almost immediately tapped Neil Gorsuch for the Supreme Court for the Scalia seat. And then Neil's going to laugh. They were able to persuade Justice Kennedy to step down, as it were, and his former clerk, Brett Kavanaugh, was put in the Supreme Court. And that one went with the hearing. Yep. And then, a month and a half ago, Justice Ginsburg passed. Doesn't it feel like a lifetime ago? It was 6 weeks ago that RBG passed away. 6 weeks. Unreal. Justice Ginsburg passed away about 6 weeks ago. And almost immediately, President Trump sounded the Amy Coney Barrett theme song, and here I come to save the day, right? She has appeared magically. She had her hearing. She got confirmed last night by a straight party line vote. Only Susan Collins voted against her from the Republican side. And she was confirmed last night. She took the oath this morning by the Chief Justice. There actually are 2 oaths. There's one oath at the White House. That one doesn't really count, right? The one that actually matters is the judicial oath by the Chief Justice. So it was kind of for show last night. But now, this morning, she actually is Justice Barrett. A lot changed. And I think the most significant area for change has actually been abortion, right? Let me tell you, folks, people still are not over Roe and Casey. They're still not over it. This past term was the first term without Kennedy for an abortion case in almost 30 years. And we had a case from Louisiana called June Medical. Louisiana enacted certain laws that restricted abortion providers. For example, the doctors had to gain what are called admission privileges. They had to be able to practice in a nearby hospital. If that sounds familiar, it should. There's a court case a couple years ago called Whole Woman's Health, where the court declared unconstitutional a law from Texas that was really similar to the Louisiana law. In the end, the Louisiana law was declared unconstitutional, but narrowly. Chief Justice Roberts wrote the maybe plurality opinion, if you will, saying, well, I think Whole Woman's Health was probably wrongly decided. And as a matter of first principles, this law is probably unconstitutional, but I will stand by the precedent here for now. That's it. Roberts signaled quite candidly that in a future abortion case, he would not feel so constrained because people didn't build reliance upon that specific type of a law. And at the time, Neil and I would probably agree, Roberts looked like he was a swing vote for a while. Yeah, not anymore. After Justice Barrett's ascension to the court, I don't think the chief is a swing anymore. The conservatives don't need him. There can be a 5-member conservative bloc without Roberts in it. And Roberts knows this. And I don't think he wants to be in dissent for the rest of his life. So he may start now, instead of tracking to the left, start tracking to the right. So he assigns himself the majority opinion. But he knows if he writes too narrowly, the other ones fracture off and he has concurrent judgment. So I think Roberts, as a matter of self-preservation, may actually become more conservative with Barrett on the court. Now the swing vote, I think, becomes either Kennedy or Gorsuch in a given case. Do I think that there are 5 votes of overruling Roe? No. Do I think there are 5 votes to overrule Casey? I do not. Do I think there are 5 votes to overrule Whole Woman's Health? Yeah, I do. Whole Woman's Health, depending who you ask, modified the Casey framework. Casey asked if an abortion restriction imposes an undue burden on the First Amendment. An undue burden on the First Amendment. First Amendment. An undue burden on the right to free speech. Long day. An undue burden on the right to an abortion, right? That's the phrase. But Whole Woman's Health added to that. Whole Woman's Health said, we look not only if there's a burden to abortion, but also if there are any benefits afforded by the law. Is this actually a health measure? Are there benefits? Some people say that was part of the Casey framework. I don't think it is, but it's not very important. Roberts thinks it's not. And Roberts said, well, I don't agree. So I think there are 5, maybe 6 votes to scale back Whole Woman's Health, which will leave us back with the Casey standard. We're back in the 1991 standard. And that standard can be read quite narrowly. So I think that's the most immediate change. Okay, now I want to move on to a related topic. What happens if the conservatives start to overrule precedents that liberals like? Well, on the agenda, of course, is our favorite game. How many justices is the right number, right? Like pick a number between 1 and 100. Like what's the right number of justices? Because it ain't 9. Court packing, my friends, is on the horizon. They're going to need to install tiers of seating at the Supreme Court. They'll stack on top of each other, like Hollywood squares or a huge tic-tac-toe board. They can all be arranged so you can all see them at once. Or if you ever see in the Star Wars movies, like where the Galactic Assembly, where they're all just in these pods floating around, right? Basically that, but the Supreme Court. I'm mostly being facetious, but not really, because it's very sad. I think we're headed there. I don't think it matters what the court does. All the efforts by the court to keep themselves out of the limelight are not going to be enough. The political process has affected this issue so acutely that I don't think the court can dig itself out. No matter what Roberts does for moderation, I think we're headed to court packing. Now, it may not be adding seats. It may be, this model where you rotate or you have panels, right? Maybe you have, senior associate justices. There are different ways of doing it by statute. I'm not sure about their constitutionality, but they're going to try. Maybe there'll be jurisdiction stripping, an old-time favorite. The court cannot hear an abortion case. Good luck with that. See if the court upholds those statutes. But I don't think that with a 6-member Roberts court, where Roberts is not really in charge, I'm not sure how much this sort of Casey model of stare decisis stands. I think that you'll see some precedents overruled for the first time in decades. And it's going to be a wild ride. All right, I'm going to shut up now and let my good friend Neil, who knows much more about the court than I do, he knows a lot more, talk. But thank you all so much for your attention.
Well, thanks so much, Josh. That was really a fantastic overview of the topic. I'm going to talk for just a few minutes so that we have plenty of time for the Q&A, and I'm really not going to tackle or disagree with anything you said. I don't disagree really with anything you said. I'm going to supplement some of the things you said, provide a little bit more detail, and then we can have the Q&A to follow that. One is just a definitional matter that I think was suggested by Josh, and I just want to bring it out a little bit more. It's something we might talk about in the Q&A, which is the notion that we need to say that if the court says that it's going to uphold a precedent, that doesn't mean it's not going to reinvent the precedent that it upholds. So the court has the ability to distinguish precedents without overruling and transform precedents. And Josh mentioned the Casey case and Casey's interpretation of Roe. Casey, in one sense, was embracing stare decisis, embracing precedent, but at the same time, replacing the trimester standard with an undue burden standard and overturning two cases that had applied the trimester standard. So when we think about stare decisis, we're talking about the actual overturning of the precedent, but the court can hollow out precedents through distinguishing. And that might be something that the court uses as a tool, and I'll talk about that in just a little bit. So that was just sort of a definitional point. Another point, and Josh did a great job in bringing this out, is the notion that when we think of the willingness of the court to overturn a precedent and the Roberts Court's willingness to overturn a precedent, we need to remember that there are now 6 conservatives on the Roberts Court, with John Roberts not necessarily being the median justice. Perhaps it's Justice Kavanaugh, perhaps it's Justice Gorsuch. We don't quite know who the median justice is, but the question will become, whether there are 5 solid votes to overturn a precedent. And as Josh mentioned, Chief Justice Roberts may not be one of those 5 votes, and he may have no choice but to either be in dissent and leave Justice Thomas with the authority to assign the opinion overturning the precedent, or for Chief Justice Roberts to join in with those 5, where he does get to maintain some control over the decision, even if it's not the outcome he necessarily would have supported. So this question of what's going to happen going forward will depend a lot on what happens with Justice Kavanaugh, Justice Gorsuch, when they assume the ability to hold the swing in a case. And will they be willing to overturn precedent, or will they prefer to go a less controversial route and perhaps distinguish precedent, or will they do a little bit of what Chief Justice Roberts did this past term and join with the court's liberals to somehow establish their reputation as being above party, above ideology? So there's a lot yet to unfold, but the key is that Chief Justice Roberts doesn't necessarily hold the cards here. The question becomes, where is the middle of the court? And is that middle of the court going to be willing to overturn precedent, or is it going to prefer a different path? And that's going to be something that's very hard to predict, and that will unfold over the years. A third general point is Josh gave a list of cases. We can talk more about this in the Q&A, but let me mention a couple of others that I think are cases where the court is likely to either distinguish or overturn precedent. One is the religious freedom case of Employment Division v. Smith, where the court essentially used rational basis review in religious liberty cases. I think there's a high probability that the court will actually overturn Smith, and this will be very important on LGBTQ issues, where the court may be willing to grant religious liberty exceptions to child care services, adoption services, foster care services, many other things, and not necessarily go back on same-sex marriage. We can talk about that later, but find ways to recognize religious objections to same-sex marriage by overturning Smith. So I think Smith is very vulnerable. I think the Chevron case is very vulnerable. That's a case that speaks of deference to agency interpretations. I think the court is fully committed to textualism now, and Chevron may already be dead, but I think we'll see the formal declaration of the death of Chevron. And like Josh, I think abortion is a very big question. I think whole woman's health is certainly gone. I think in some measure it was gone in the June medical case. Chief Justice Roberts, upheld whole women's health as stare decisis, but with an asterisk saying, I'm only doing it in this case because the Fifth Circuit wasn't paying attention to the Supreme Court, but I'm not committed to whole women's health at all beyond this case. So whether whole women's health is even law today, it certainly won't be law going forward. I think the question of Roe is a pivotal question. There's been a lot of concern by the progressives and the Democrats that Roe will be gone with Justice Barrett on the Supreme Court. I think it's way premature to say that. Justice Kavanaugh tried to avoid the June medical case, tried to have the case sent back to the trial court for the court not to have to tackle it. I think at least Justice Roberts and Justice Kavanaugh and the court's Democrats would prefer to avoid tackling the abortion issue, but whether they can is another matter. Whether there will, I think we can imagine a federal court of appeals upholding a law that is inconsistent with Roe to set the stage for the court being forced to reconsider Roe. And I think it's very hard to predict what will happen. And this brings me to my final point, which is the court packing point that Josh mentioned at the end of his comments. And if the court were going to overturn Roe, it would make court packing far more likely. If the court reaffirms Roe in some fashion, even if it embraces Casey and clarifies that whole women's health is not the standard, I think the court might be able to stave off the court packing by making use of, as I noted at the beginning, distinguishing rather than overruling. And even if you overrule some cases, but not many, and mainly rely on distinguishing, I think that may well protect the court from court packing. It may not protect the lower federal courts. There is this question of whether the lower federal courts will become the target of the expansion of the federal judiciary, just because that's much more routine, far less controversial than actually trying to overturn specific decisions of the Supreme Court through court packing. And that's something that we might see no matter what, to change the general face of the federal courts. But with respect to the Supreme Court, I think if the court does not overturn a significant number of precedents, particularly the Roe precedent, it may be able to stave off court packing, and we'll see what happens with that as time marches on. And of course, one of the things that distinguishes this moment in time from the FDR court packing efforts is we now have this partisan divide on the court. So when if the Democrats were to gain control of the Senate, the House, and the White House, there would be much more of a focus on the court as a Republican court brought into power by Republicans who played hardball politics, and fair play, so to speak, for the Democrats would be to respond in kind with court packing. But I think it would take a trigger like the overturning of Roe versus Wade. So that's a lot of stuff. I just wanted to throw that out to help set the stage for the Q&A. And that's all I need to say at this point until we get into questions.
Thank you. Yeah, I have nothing to add. I think we agree on just about everything. Carson, you want to go to Q&A?
So reasonable, right? There's nothing descriptive. We're not taking positions on what the right answer to any case is. We're taking a general view of when the court will employ stare decisis.
Yeah, and I think that's actually a good thing to comment on. So much of our debate in society is rancorous, where people yelling at each other on cable news, and look, Neil and I have known each other for some time. You can do it better, right? All of you can do better. And I think this is a good model of how to engage civilly, even where you don't agree. You find your points of agreement, and then you sort of fracture up from the other sides. But we're all in this together. All right, so maybe Carson wants to do some Q&A?
Sure, yeah. So if everyone, you guys can start typing them in the Q&A, but we already have one. So I'll go ahead and pose that question to you all. So one of our attendees asked, to what extent do you think Chief Justice Roberts will return to more conservative opinions as before he became the median justice, and how will he try to maintain his control as chief when he's no longer the swing vote?
Yeah, it's a really good question. Thank you for that. The Chief Justice is described as the first among equals, right? He's not actually in charge. It's kind of like a myth, but he does have one power that's important, in that he can assign the majority opinion when he's in the majority, right? As the chief, he has the most seniority, but no matter how long he's been in the court, and he can assign the majority. And that can be used very effectively. What you see in the last 2 terms is that Roberts gives himself all the biggest cases on tax returns, on DACA, right? All the big cases, they're his. Obamacare, even before that. And that way he can sort of craft the majority opinion. And he needs to be in the majority because other 4 people have to come along with him. And if they don't like it, it's really too damn bad because he's in charge. Yeah, not anymore. Imagine that Roberts assigns himself the majority. It's too moderate. And then Barrett, Gorsuch, Kavanaugh, Thomas will like, yeah, that's nice. We'll write our own opinion for 5 and your concurrence, right? So in other words, the Thomas wing can start writing the majorities they want without having to worry about the chief. I don't think the chief is ready to relegate himself to a career of obscurity, sort of on the outside looking. He doesn't want to be a dissenter, right? It's very rare for the Chief Justice to always be in dissent. Just historically, it hasn't happened. Chiefs have usually been in the majority. I can, maybe Devin has a better history than I do, but Devin, has there ever been a chief that was consistently in dissent? I'm blanking on to think of one.
No, it's interesting. So Chief Justice Rehnquist, of course, had the reputation of being the lone dissenter when he was an associate justice.
Right. Yeah.
And he assumed the mantle of Chief Justice. The world had changed in ways that he was certainly in the majority more often. Not at the rate that Chief Justice Roberts was last term, which was extraordinary. But,
it was.
Yes.
So
yeah.
I think Roberts will find a way to be in the majority. And if that means tacking to the right, that means tacking to the right. He's going to try and keep his troops together, but I think there's evidence he can't do it. Look, last night, there was an emergency order in a case from Wisconsin about it has to do with how late can you postmark a mail-in ballot, right? Can they be postmarked after the litigation? I'm sorry, after the election? The facts are complicated, not important. But the court fractured. There were 5 votes that said, no, you have to leave the deadline as it is, but there's no single rationale. And Roberts wrote this sort of frantic 1-page opinion saying, I'm just granting relief here, but don't ask me about Pennsylvania. That's a different case. And then if you read Kavanaugh and Gorsuch, you're like, yeah, Pennsylvania is getting reversed also, right? There's the other cases in the pipeline. So there's fracturing. And, if Justice Barrett sits for election litigation, which he very well may, then I think Roberts is going to have to say, okay, well, I can either be in dissent or I can write the opinion. So he's going to find a way to write the opinion. What do you think, Neil? How do you think Roberts responds to this new world?
So, I agree with your basic premise, which is Roberts is not going to want to limit his authority by being in dissent. He actually agrees with the conservatives almost always. There are several notable cases, and they're the cases that everybody's focusing in on, where he broke ranks, so to speak. But I think in those cases where, he did break ranks, and now with Barrett on the court, he would be in dissent. I think in several of those cases, but not all of those cases, he would switch positions to control the opinion. Now, this is very important also for the Starry Decisis question. So Roberts probably has a strong preference not to overturn and to distinguish. So one of the things that might happen is we might see Roberts move to the right so that he can control the opinion and have the opinion be an opinion that distinguishes rather than overrules. Because for reasons you noted at the beginning, Josh, if you overrule with frequency, there is this sense that you're acting in a sort of partisan, lawless way to advance some ideological agenda. So Roberts may try to save the court and its legitimacy by finding ways, creative ways, to distinguish cases. And that might be more of the action than actually having an affirmative agenda to undo precedent and move forward in a more dramatic fashion. So that might be the big fight in the court, is whether they're going to overturn or distinguish.
Very good. Next question.
Yeah, so we have a question here. Someone's wondering about really the role that the Supreme Court could play in a potential court packing situation. I guess are there any tools that the Supreme Court could use against a situation where Congress and the president just want to push forward with packing the court? Is there anything that the Supreme Court can do to push back on that?
Yes. Well, look, let's go through this one step at a time. Can Congress add seats to the Supreme Court? Absolutely. In fact, the most constitutional thing they can do is just add seats. There's no problem if they add 11, they add 13, whatever the number is. There's no fixed number. The Constitution does not say 9. It's not a magic number, right? So if Congress passes a statute that adds 2 more seats and they're confirmed, I think the court has nothing. They can't stop it. Now, there are various proposals to do something short of that because it seems very unpopular. One proposal is term limits by statute. I am very skeptical that you can impose term limits by statutes. I think you need an amendment to the Constitution for that. Another proposal says, well, you don't term limit the justices, you make them senior status. Is that what they call them? I think senior status. So after 18 years, they get to sort of retire to Mount Vernon, right? They can go ride circuit and go to the circuit courts, but they can't sit on the real Supreme Court. Or maybe another option is panels, where you have, you always have 9 justices in the bench, but if a justice is over the age of 18 years, they just serve on standby in the bullpen. And if there's a recusal, they can step in, right? Another proposal is to have lower court judges elevate to the Supreme Court. Another proposal is jurisdiction stripping. You learn this in Fed courts, where you actually tell the Supreme Court, you can't hear these cases. Another proposal is, instead of having 5-4 to overrule a law, you need 7-2 to overrule a law, a supermajority. Another proposal I saw recently is to declare a law unconstitutional. It has to be manifestly unconstitutional. Look, I'm giving you all these proposals, which I think a lot of these would be just declared invalid by the court and just it'll be a waste of time, right? If you want to do it, bite the bullet and just add seats. If you try to do something short of that, you're going to lose. Neil, I mean.
Yeah, I think that's clearly right.
Yeah.
I think there's no question that the Congress can change the number of justices. And then you get into the complex question of how many justices, if that comes to pass. And it seems that the Democrats, if they control all of government and they do pack the court, would go with 4. But that'll come at a cost as well, because there's no principled reason to say 4. I mean, I think that you can fairly say that the Garland seat should have been the Garland seat, but I don't think you can say the Garland seat should have been the Garland seat, but the Barrett seat should not be the Barrett seat. So I think there are going to be real complications for the Democrats going forward, which is why I suspect, particularly if the court is distinguishing and not overturning, the action will be really with the lower federal courts more than it will be with the U.S. Supreme Court, because very few cases get to the U.S. Supreme Court. And if the Democrats can flip all the circuits and have all Democratic circuits, that's not quite as significant as controlling the Supreme Court. Clearly not, but I think it will change the dynamic in ways that might be politically acceptable, certainly to President Biden, assuming candidate Biden becomes President Biden.
Thank you.
We have another question. I'm kind of asking about Justice Thomas's concurrence in Gamble, where he talks about his own views on stare decisis, and asking how that particular, maybe more apt to overrule cases than other justices, how that might play into Chief Justice Roberts' decision.
Yeah, Justice Thomas is sort of unique on the court in that he's never seen much value for constitutional stare decisis, and I think I'm putting that charitably, Neil. It was just never very important to him, and the reason why it was never very important to him is because he always assumes that if a court's wrong, then you should get it right. Justice Thomas was sometimes viewed as a bit of a crank, that maybe he was just a Scalia clone, that Scalia was really pulling the strings. If you ask Scalia, is the opposite. He said Thomas would push me to the right. It wasn't Scalia leading the way. It was Thomas. And Thomas has basically had this ascendant moment where now he's a senior associate justice. And if the Chief Justice Roberts is not in the majority, then Thomas is. And Thomas give himself the majority opinion, or give it to Justice Barrett, or give it to Justice Alito, right? So I think Thomas has never been more powerful. Another related component is Thomas's clerks are getting on the federal bench at a very high clip, and they're doing very well. Justice Naomi Rao, Greg Katsas, Jim Ho, right? All of these Thomas clerks are just making a name for themselves in profound ways in the lower courts. So again, people try to marginalize CT. He's living his best life at the moment, and I think he you could see him smiling at the White House was it last night? Oh my God, last night he was smiling because he's like, all right, this is cool, right? I'm going to ride my RV to victory. He has a huge RV that he drives around the country when it's not a pandemic. So the short answer is, I think Justice Thomas will be very keen on revisiting old precedents, and if he can bring 4 or 5 along, then maybe Neil's hopes to avert court packing are short-lived. I don't think Thomas gives a damn about what they do to the court. If they want to pack it, let them pack it, but that'll be on them, not him. I don't think he's afraid of, or I don't think he'll moderate himself. I don't know where Kavanaugh and Gorsuch come down. They might be afraid of court packing also. They might say, YOLO, let's go, right? It doesn't matter, right? They're going to do it. Let them do it. Let's do what we think is right. I think that's the conflict we saw in the Wisconsin case. Roberts is trying, like holding on to a bucking stallion, trying to hold it back, and eventually the reins will slip. And I think they slipped last night.
Yeah. So I not shockingly agree. I will say a couple things. One is we'll find out whether Justice Thomas is interested in building 5 justice coalitions to achieve his jurisprudential agenda with some compromises, or whether he's going to stick to his views without compromise, and that may actually make it easier for Chief Justice Roberts to find a path towards getting a group of 5 to distinguish a case. So it'll be interesting to see whether, with this power that Justice Thomas clearly now has, whether he's willing to use it strategically, because up until now he's spoken his mind. He's spoken it very well. He's been very influential for the reasons Josh has said. And then the question is he willing to become influential more as a politician, as a deal broker, which is not part of his legacy up until now. The second comment about Justice Thomas is just an irony. Shortly before the death of Justice Ginsburg, there were people saying that Justice Thomas should resign to pave the way for President Trump to appoint a conservative and secure that seat for the court, under the view that if he didn't, it would result perhaps in a shifting in the balance of power on the court, and his inability to have the outcomes he prefers be the outcomes the court went with. So this was the argument for him to retire, the same argument that was made for Justice Ginsburg to retire many years ago. Justice Thomas did not take the bait, and I'm guessing, I'm sure the death of Justice Ginsburg was something he was very sad about. But in terms of his ability to achieve his goals as a justice, his decision not to retire proved to be a very wise decision.
Yeah.
That's from his, I'm not saying from the nation's perspective or anything like that, but I think from the perspective of Justice Thomas, he probably feels he clearly did the right thing. And now we'll see how influential he will be. This is his moment.
Yeah, I agree.
Right. And I think we probably got time for one more question. And I think this one's a good one to end on because it's kind of forward looking. And so what kind of jurisprudence, I guess, should we be looking from Justice Barrett? And what current justice should we be looking to kind of compare her opinions? And are there any of the current justices that she's most like?
I think it was significant, Neil, that Justice Thomas swore her in and not Justice Roberts. Did you notice Roberts didn't do the swearing, and I think he wanted nothing to do with the White House right now.
I think yes. With respect to the Federalist Society event, obviously, Chief Justice Roberts is kind of sort of member of the Federalist Society, unlike the other 5 Republican appointees who are clearly rock solid members of FedSoc. And yes, with Judge Barrett, she has not been on the Seventh Circuit that long. I think it's hard to make strong predictions as to, who she will be. I mean, she is, embraced, obviously, the justice who she clerked for, Justice Scalia. So I think we can expect her to embrace textualism, originalism, but where that will lead her and how she will interface with the other justices in that coalition, truly remains to be seen. There's a lot we don't know about her that will be revealed in the years ahead.
Yeah, I agree. I think Barrett will be closer to Justice Thomas. I think she'll be in the Scalia mold. I don't think I think she's going to approach originalism in a very candid way. And let me just take a step back. I think Justice Barrett's most important contribution is not going to be just in the bench. I think she has the personality, the charisma, the presence to elevate to the next level. Justice Scalia, when he entered the room, it was electric. And when Justice Ginsburg entered the room, it was electric. I think Barrett can bring that same thunder and really give the conservative movement a face it hasn't had in a while. And I think it's important to say it's a woman, right? I think generations of conservative girls will see this as an icon who they can look up to and recognize that you can be conservative and you can be a successful woman and they're not inconsistent. You can practice your faith, you can believe what you want to believe, and you can achieve the pinnacle of your success. And I think what I'm most happy about Justice Barrett is not even her opinions, but I think what she can bring to the movement, because culture is more important than any decision. Decisions people forget, right? Case books are rewritten every year, but the cultural impact of Justice Barrett, I think, will endure far beyond the Trump presidency in ways I'm very, very happy about.
Yeah, I think that's a very good point to bring up. I think Justice Barrett, will have a pretty wide open field to run in to lead the quote unquote conservative cause going forward. And I think those points are very well made. And it's very important to realize, particularly with the Federalist Society, that being part of a social network can turn into, shaping the direction of the court's doctrine. And I think the Federalist Society has clearly played that role with the court and will play that role in a more decisive way going forward.
Thank you for attending a Federalist Society meeting.
Right. Well, unfortunately, I think we're short on time here, but thank you so much to Professor Devins and Professor Blackman for being with us today and talking about these issues that are really highly relevant to all of us at this time. So so everyone just be on the lookout for our next event. I think this will probably be the last one of the semester, but we're working on getting our next semester slate of events up and ready. So be on the lookout for that. And until then, thanks again, Professor Devins and Blackman, and hope everyone has a good afternoon.
Take care.
Great. Thank you.
Bye now.